I'm going to get us started, and I'm joined by Liz Boyce, the Director of Policy and Advocacy here at TAASA. My name is Kristen Lenau, and I am a Senior Policy Advisor here. And so both of us, in addition to our former colleague, Catherine Strandberg, as well as our Executive Director, Rose Luna, were really spearheading a lot of the legislative priorities for the 87th session. So we wanted to kind of lay out a little bit of the context and environment that we were looking at when we started going into the legislative session this time. About a year ago, we were hearing from our lobbyists as well as from other advocacy organizations that it was going to be a very abbreviated session, that it was likely that very few bills would pass, and that we should really set our expectations very low in terms of what we would be able to get done as an organization. So for us, we really wanted to ensure that we maintained a clear focus on the budget. And so as many of you may know, we do contract with a lobbyist, and her job is to ensure that rape crisis center funding remains intact and to address any shortfalls or increases during the session that we are advocating for. So we wanted to ensure that you all knew we were going to prioritize budget advocacy above the non-funding priorities that we were hoping to carry. We were looking at limited virtual options for testimony. So, in December and January, we were getting a lot of questions from membership, from the public about how to engage at the Capitol during the pandemic. And the House and Senate did not release rules of public engagement until January. And so we were working in an environment where there was just so much uncertainty. And we had to move forward with the belief that it was likely that the majority of our members wouldn't have direct access to the Capitol, or if they did, it would be in a really limited capacity. And as we moved forward through the session, that became even more apparent as there were very, very limited options for virtual participation. So this overall just had an enormous impact on the amount of engagement and access that our membership, y'all, survivors, were able to do this session. And so in order to alleviate some of that, we developed a short set of streaming videos called TAASA Talks with Rose Luna, our CEO. And in order to provide y'all updates, we really tried to pivot and focus on written testimony and phone calls because we knew that every single committee hearing, every single member had a different set of rules for how they would allow the public access. And so this just presented a lot of challenges in general, but particularly for people that don't live nearby. So we had a lot of people that really wanted to come and participate, but the uncertainty around whether or not they would be able to access the building and how they would be able to do so just became a huge barrier. So we do have some really awesome news on the budget. Our organization advocated for and was successful in receiving a $4.7 million increase in the SAPS fund. And that line item goes directly to rape crisis centers in order to provide the minimum services to adult survivors of sexual assault. And this brings up the total line item over the biennium for this fund to around $29 million. So this was a significant increase for us, and we're super grateful to the legislative champions, Senator Huffman and Senator Nelson, for ensuring that this happened. We were hearing over the last 2 years that while the previous increase had gone a long way to addressing waitlist and counseling, that the pandemic really impacted the amount of calls and requests that centers were getting for counseling, and it also impacted their ability to provide services. And so this additional funding was directed to continue to put survivor counseling wait lists as a priority. I'm going to go ahead and mute. There we go. Okay. So now we're going to move into our non-funding priorities, and I'm going to hand it over to Liz to talk about our first couple of items.
Thanks, Kristen. Yeah, so we wanted to talk first about our privilege bill because it's one that we've really wanted to happen for a long time. As long as I've been at TAASA, we've been thinking on this and working on this. And as you know, right now, up before this bill was passed, sexual assault advocates didn't have the same legal protections of privilege that family violence advocates were able to offer to survivors, which, that passed a couple of sessions ago. And we really, really wanted to alleviate that discrepancy, especially for our dual programs that see both survivors. So now we're happy to report that this is a thing that exists in the law. And any adult survivor of sexual assault who seeks help at a rape crisis center can now, well, starting September 1, assert a privilege over the documents and the communications that they share with an advocate. So this already, we had the confidentiality statute that we could use to just strengthen those provisions, and we could knock out the ability for the state to just subpoena documents just to be proactive, even if there was nothing in them that would help the criminal case. This really shields survivors from that attack on their privacy. And so there is, though, a very narrow exception. We did have to comply with the Michael Morton Act in the event that there is exculpatory evidence that exists in that private communication. Now, a defense attorney can seek production of documents, but it has to be produced under seal, so it's still a very private sharing of that information just for the judge to review in camera. And so if, in fact, after that review, the judge determines that the documents do have exculpatory evidence, in other words, that it is something that looks like it could relate to innocence of the defendant, then he has to go ahead, or the Rape Crisis Center has to go ahead and share those documents. It has to be provided to the defense. And so this is a very narrow exception, and one that still affords a survivor with a lot of privacy protections, much stronger privacy protections than they had prior to this bill. So we're very excited that got through. We'll move on to the next slide now, Kristen. Thank you. So the next thing that we wanted to talk to you about today was our trauma-informed investigations bill. And this one was intended to really look at the survivor's experience and try to make that a more trauma-informed experience as they go through the criminal justice process, as they go through those investigations, if they choose to report. And so it does basically three things. Number one, it affords them with the right to have an advocate during law enforcement interviews. Now, there's been some questions about how much this is going to impact programs. I want to put your minds at ease right now. This doesn't mean you have to be at every single interview. This doesn't mean that programs have to be there on the scene when a survivor, goes to the hospital necessarily right away. Well, they have to go for the exams, but if the police are coming to the hospital where there's that communication there, that we're not talking about first responder situations. This is when there's a planned, scheduled interview and the survivor wants to have an advocate there and this advocate is available, then law enforcement simply cannot keep them from coming into the room. So this is something that's intended to be a very survivor-focused law. And there's going to be occasions where conversations are going to happen with law enforcement and the survivors maybe not in the room, but the idea is it's the survivor's choice. If the survivor wants to have an advocate there, then the intention is that every opportunity be made to provide that if possible. And if a rape crisis center does not exist in that county or simply is not available for that interview, then the next step is to ask if a victim services liaison, somebody in that office or somebody in the county can perform that service for them. So So it's just intended to provide them with that little extra layer of comfort. Additionally, this bill provides a statewide ban on polygraphs. And so in the past, what we were seeing is it didn't happen all the time, but there were still occasions where police would just simply ask the survivor, would you please take this polygraph? And didn't require it. They weren't allowed to require it, but they would ask in some situations. And now that's just simply not allowed. It just provides a statewide ban because, you know, in that moment in time, it's very unclear to many survivors that that's actually a meaningful choice for them to say, no, I really don't actually want to take a polygraph. And so they might be concerned, well, if I say no, are you really going to investigate the case? Are you going to believe me? So we're just going to take that element completely out. This does not allow them to ask. So the third thing that this bill does is, we believe, possibly the biggest thing of all of the three things, which it makes certain that law enforcement does not have the right to decline exams for any reason. You may recall that there used to be a very narrow exception in the law that allowed, even when survivors would come to the emergency room or come to report within 120 hours of their assault, that law enforcement could say, no, we don't want to authorize the exam because of this one narrow exception that says if there's prior false reports and no corroborating evidence in this case. And so they would lean on that exception in some cases unfairly, and it just didn't belong in the law anymore. And frankly, you know, in conversations with stakeholders, it's clear this should be, again, a survivor's choice, not a law enforcement choice. And it is a crime victim's right to be able to get this exam within 120 hours. So why are we putting additional barriers in place? So we're very pleased to announce that narrow exception is now gone. There's no reason for any survivor to be declined an exam within that first 120 hours. Also, there were some comporting changes. You might remember last session it was increased the amount of time that survivors needed to report to have that right to an exam. It increased to 120 hours. There were some issues with codifications of the Code of Criminal Procedure. It got missed in getting published, so there were some changes around that to comport with the last session's work. And so, ultimately, we feel like these three pieces really will make a huge change to the criminal justice process as survivors step into that area, and really encourage survivor choice to be respected. I'll hand it back to you, Kristen.
Thanks, Liz. All right, so I'm going to talk about sexual assault response teams. So SB 476 was a priority of ours, and we were looking at mandating the formation of collaborative community responses or sexual assault response teams for every Texas county. And this law will require that rape crisis centers, sexual assault nurse examiners, law enforcement, and prosecutors, as well as mental health, behavioral health providers, start working together more collaboratively to develop a written protocol for their communities for adult survivors that make an outcry. And so this law goes into effect in September, along with the other ones we're discussing today. And we're really thrilled about this one, and we are currently working on a guide for our membership as well as other stakeholders to help support implementation. We know that people have a lot of questions. We are absolutely here for you to answer those questions, to provide training for your community. And this one was really important as we were seeing over and over again a lack of communication, a lack of collaboration, a lack of transparency amongst different stakeholders in Texas communities. And this was impacting the way that survivors are being responded to, and whether it is that they don't have the presence of an advocate, or they're not offered an exam, or no one knows where to take them when they make an outcry. Whatever the issue is, we hope to see this collaboration and the protocol that is a requirement in it to begin to tackle some of those just really basic crime victims' rights that are, hard to enforce, frankly. And so survivors have a lot of rights that have been given to them by the legislature. And this bill is really designed to start requiring people to work collaboratively in their communities to ensure that those rights are addressed. And this one did pass. And again, we're super thrilled about it and happy to answer questions from communities as they start to work on this collaboration. So these other two items, we started out with one priority around addressing a couple of different loopholes in the penal code. As I'm sure many people are aware, our sexual assault statute and the way that we talk about consent in our sexual assault statute is it's complicated, it's confusing, it causes a lot of issues for everyone. And so what we see session after session are attempts to remedy some of the gaps in that statute. And, ideally at some point in the future, we would like to see that statute get in a complete overhaul. But in the meantime, we get bills every session, whether they're a TAASA priority or they're coming from other arenas, to start to tackle some of the more glaring issues in that statute. And so there were two items that we addressed this session, one of which passed, one of which did not. The first was SB 312. And so what this bill does, it looks to address the power difference that impacts consent between law enforcement officers and people that they're detaining or who are in custody with them. So improper sexual activity in custody is already considered a crime. Previously, it was a lesser penalty than a sexual assault in 2211. So this enhanced the penalty to put it in line with the other sexual assault statute, which prohibits sexual conduct in other relationships where there is that inherent power difference. And so that bill did pass. And the second piece was looking at closing a gap in the penal code around professional deception as a means for gaining consent for sexual contact. And this really came out of a number of different issues that we were seeing around the state where in a variety of contexts, we were seeing issues with fake doctors pretending to do exams on people under the guise of medical or mental health care. And so these are people that were unlicensed to practice like any kind of medicine. And we're telling people that what they were doing was treatment for them. And so this bill was attempting to address that kind of professional deception in the penal code. It did not pass, unfortunately. We do think it'll likely get taken up again in further sessions, but for now, that remains a gap. Hand it back to you, Liz.
Yeah, so we're going to talk just a little bit about some of the Sexual Assault Survivors Task Force bills. Those of you who've been kind of watching over the session, our TAASA talks, might remember we've talked a lot about these bills. The task force came up with 11 policy recommendations as part of their process, and that ultimately produced 3 separate bills, and we're going to talk about 2 of those bills. The third one actually was subsumed within this one that we're going to talk about first, 2462. So this is a bill that it incorporates many, if not most, of those policy recommendations from the task force. And again, it takes effect on September 1. It makes changes to the Code of Criminal Procedure and the Government Code. And it overlaps to a degree with the 1172 that I spoke about a few minutes ago, our Trauma-Informed Investigations Bill, in that it also includes that removal of the ability of law enforcement to decline an exam. They both do the same thing. The language is the exact same. The additional thing that this bill does is also require forensic medical exams for minors. So if this is for acute and non-acute exams, so there's no timeline in place. If a minor reports, there's to be an exam, and again, there's going to be need for guidance around this. CAC Texas is planning to put that out shortly, but we would just encourage you to work, if you work with minors, to work with your local forensic providers as well as law enforcement to kind of figure out timing around what that looks like, recognizing that the non-acute exams may not have to be as immediately scheduled as some of the acute exams, certainly, but it's intended to, again, remove barriers and also find out if there is other abuse happening that maybe an exam would shed light on. So in addition, it does help ensure that forensic examiners get that direct reimbursement for the cost of the forensic portion of the exam. And then again, it makes those conforming changes that we talked about before from last session to extend that time for an exam. Next slide, please. And so the 2706 codifies safe, ready facilities. And so what does that mean? You might remember a couple of sessions ago, I believe, that there was a bill that was passed that actually came up with this term, safe, ready facilities. And what it was defined as is any hospital, and that's the key word, any hospital that provides forensic exams that they employ or they contract with a certified SANE. Well, that's great because it allowed survivors to be able to know exactly which hospitals to go to. There's a list on HHSC's website. And so, this was a really good, well-intentioned bill. But the problem with, as happens in many cases with policy, is there's a gap that was left for these community-based clinics that are not affiliated with the hospital. So unintentionally, they were left out of that bill. They were therefore not able to be eligible for certain grants that were only eligible. You had to be a safe, ready facility as that term was defined. They couldn't apply and receive reimbursement for emergency medical care. And this was a big problem, specifically as it related to prophylaxis. So what the task force decided was to actually just broaden that definition, that codified, that code definition of safe, ready facility, to codify these community-based clinics and bring them into that meaning, that definition. So what it does is it calls these clinics safe programs, and it includes them in that definition so that they can, in fact, get that direct reimbursement as that's going to make them more sustainable, and also be eligible for those grants, again, to enhance their sustainability. Also, they'll be added to that list of safe, ready facilities that's included online, and that's going to have to be updated every quarter. So to make sure that this is an ongoing list, and we're encouraging the development of these programs, because what we found is they do provide a high level of service to survivors. So in addition, there are some minimum standards that these clinics have to meet to make sure that, we're making sure survivors are well taken care of. And it's a very long list. I won't go into all of the things, but it was very well thought out and well and designed by actual forensic examiners who sat down and really thought through what would be the best standards that would need to make sure these clinics are top notch. The other thing, can we go to the next slide, Kristen? The other thing that this bill does that's also survivor-centered is it has an immunity clause right at the top that says that any evidence collected from an exam can't be used to investigate or prosecute a survivor for a misdemeanor that's been alleged to have been committed by them. So, this is nice, and it enhances that level of comfort to come and get an exam. It again makes those conforming changes we've talked about, extending that 96 hours to 120 hours. It also removes the term alleged, and this was also done by the prior bill I mentioned, 2462. It all throughout those codes now, it used to say alleged victim. Now that alleged has been stricken because it just gave this sort of appearance of, we can't quite trust the survivor. So all of that's been stricken to make it a bit more survivor-centered. And then it also requires that healthcare facilities that aren't SAFE-ready, when they're referring to a SAFE-ready facility or a SAFE program, that they provide them with a list of nearby facilities. The language used to say the closest one, and that seemed to limit options. So this sort of opens up those options, again, making it a bit more survivor-centered.
Okay, so moving on from the list of TAASA priorities as well as the Sexual Assault Survivor Task Force priorities, we wanted to spend the remainder of the presentation just highlighting some other significant areas of legislative changes. And we're just going to be really briefly touching on these bills. A lot of them we, provided a small amount of support. Several of them were priorities for other coalitions and organizations. So if you have like more detailed questions about any of the bills that we're going to talk about from here on out, if we can't answer them, we can absolutely, direct you to other folks that can. So the first one, SB 1164, this actually is very similar to one of our priorities, the fake doctor, the Larry Nassar bill that we were working on. This is another area in the sexual assault statute around a relationship with power dynamics, and it addresses including the student, teacher, or a coach and a student in a list of relationships where there is an inherent power difference and consent cannot be given. And so this one did pass, and so that will be added to the statute for September. HB 721 requires that TDCJ, prior to releasing an inmate who's in county jail on mandatory supervision, notify any victim or victim's guardian or relative that this inmate is eligible for release. And so it also allows the victim to send in a written statement to a parole board that they have to take into consideration when they are thinking about releasing someone. HB 1706 allows the county or any county in Texas to consider creating a specialty court for sexual assault cases. And so this would be a voluntary court process for victims. It requires that the judge and the prosecutors that operate in this court have experience with sexual assault cases. And they would also be obligated to create and publish procedures and make those publicly available so that victims can be more aware that this is an option for them. SB 957, this is a fantastic bill. It was a priority for the Crime Survivors for Safety and Justice, which is an advocacy organization. And so this one specifically relates to payment from crime victims' compensation. So as it stands right now, only victims of violence who substantially cooperate with law enforcement are able to receive CVC reimbursement. This law kind of softens that stipulation by saying that a victim who doesn't want to speak to the police either at a crime scene or at the hospital immediately after a crime can't immediately be labeled as uncooperative unless they continue to disengage with the police. So it allows victims of crime to have like a breathing period before they are really required to start interacting and engaging with law enforcement in order to have that option for CVC reimbursement. And then the last one that we wanted to highlight related to the criminal justice ones was a priority for the Texas Council on Family Violence. And that is a requirement that conditions of bond for certain violent interpersonal offenses, including sexual assault, including family violence, be entered into the TCIC, which is the essentially like the dashboard that police officers have access to by within, I think it's 24 hours of those being imposed by a magistrate. And so what this will do effectively is that if a sexual assault perpetrator or a family violence offender is scheduled to be released on bond, if there are conditions of bond, say, staying away from a certain residence or prohibition on firearms, those conditions have to be entered into the system and immediately accessible to law enforcement so that they're visible anytime that law enforcement needs to check on them. It also requires that the victim be notified about those conditions of bond because previously those may have been imposed by a magistrate without a victim even being aware that they were imposed. So they couldn't report a violation if it occurred. Okay, and Liz, I am going to hand it back to you.
So these are a couple of bills that relate specifically to protective orders, and we see bills related to protective orders every session. I feel like it's a common one that we still need to keep working on. The first of these is 1372, which relates to phone accounts. And so those of you that do family violence work, you're probably very familiar with the fact that when you have a mobile phone service contract, only the primary account holder can make changes to the plan, and that perpetrators of violence often use this as a measure of control over their spouses or significant others, to isolate them and to cut off their sources of support. And so this bill basically protects them by authorizing the separation of the wireless number from the account of the primary account holder via court order. So they can actually go show their protective order and remove the subject of the protective order from that account. So the other thing that we wanted to talk about was HB 39. And this is a very long and complex bill. And we just wanted to highlight a few things that we felt were the main takeaways from this bill. The first piece of it has to do with agreed protective orders. And so some of you might remember cases that you've dealt with where, there's an agreement that comes about between the survivor and her, the perpetrator, the offender, who maybe the offender says, well, look, I'll agree to this temporary order, or this protective order rather, but I don't want it to say that I've committed family violence. So maybe that's a condition of the agreement, and the judge goes ahead and signs off on that order, but it doesn't have that statutory language that shows the findings specifically in the order. So there was some confusion leading up to this bill of, well, is that really an enforceable order? This bill makes it clear that is an enforceable order, civilly and criminally enforceable. So don't have to have any more confusion around that point. And as far as default orders, again, a lot of confusion had started to bubble up around what happens when a defendant is served, doesn't show up, and the judge wants to go ahead and sign off on a default order. Well, some people were arguing, and it actually got up to the Court of Appeals and the Supreme Court about, well, in other civil cases with a default order, that service of process has to be on record at the court for 10 days before that judge can sign that default order. So what about that? These are emergency orders, so there was a conflict about that, and there was even a conflict among the Court of Appeals about that point. This bill puts that to rest, makes that clear. This bill clearly says, and now the law clearly says, that if the respondent is served with process just in the ordinary way, he's got personal service, that there's no specific amount of time that needs to elapse between that service and the judge signing on the default. So there's no requirement it be on file for 10 days. It's a different type of default order from other civil cases. The next thing this bill does really closed a loophole in the protective order statute that existed. In the past, we were hearing about adult victims who are wards, who have a guardian, and that there's really no standing for, a person who's a caregiver for that person or their guardian for them to file for a protective order to protect them. So this bill makes it clear that any adult can apply for a protective order for those adult wards. In addition to that, it also opens it up to any adult can apply for a protective order for a child. So that really does make it quite a bit easier for those orders to be filed. The rescind means ask for it to be, terminated, essentially. And this basically, it's kind of a no-brainer that says that parents that are alleged perpetrators may not rescind protective orders that they are subject of. So that probably should have been done a long time ago. In addition, it requires prosecutors to go ahead and file for a sexual assault protective order in cases where the defendant has been convicted and gotten deferred adjudication or probation. So, in the past, we had this requirement that they file, but I think there was some confusion around, what happens if they get probation, still have to ask for the protective order even in those cases if the victim actually consents to that, wants that to happen. It's still a survivor-centered law.
So I'm going to touch very briefly on 5 human trafficking bills that passed this session, also acknowledging that there were more, and some of these are quite extensive, and it's just we don't have enough time to really cover all of the different provisions. And a lot of these arose from the state's human trafficking prevention task force. And I'm not sure how familiar people are, but it's a group of stakeholders. It's a little similar to the Sexual Assault Survivors Task Force in that they also produce a report for the legislature and make policy recommendations. So the first one is the establishment of a trafficked persons grant program in order to provide dedicated funding for both housing and treatment. And this is going to be administered through HHSC. It's going to be funded through fees from specialty driver's licenses and plates, and a couple of other transportation items. HB 3521 expands the definition of coercion as it relates to human trafficking. So it expands to include situations where a perpetrator is using like the threat of documentation, withholding documentation, concealing it. Also, it includes situations where the perpetrator is using alcohol and drugs to create a dependency, as well as using them as a way to control a victim. HB 390 places a requirement for both signage and trafficking on signage and training on human trafficking for all hotels and commercial lodging establishments in the state. And it does require proof of compliance and civil fees that are going to be imposed by the Office of the Attorney General. The length of the training is not, I don't believe it's specified in the bill, nor is it specified who will provide that training. SB 1831 is an amendment to the Penal Code. This is a larger bill. It enhances the penalty for solicitation of a minor in situations where that occurred during school hours or on or near school premises or school function, and when the offender knew that this minor was in school at the time of the offense. And then 1540 was an omnibus bill that came out of the task force. And this does a number of different things to both enhance the criminal penalties, but also civil liability that can fall onto businesses, childcare, residential licensing penalties for trafficking that takes place at or near those types of facilities. and it cracks down on drink solicitation. So it uses the Alcohol and Beverage Commission, their ability to revoke a license if they become aware that there is a drink solicitation situation happening at a bar. So again, this was a huge bill. I'm not going to go into all the different pieces of it, but happy to talk further about that with anyone who's interested.
So we're going to conclude today with an overview of these sexual harassment bills. HB 21, it does something I wish had been done a long time ago, which it makes it a longer period of time for a person to file a sexual harassment complaint to the Texas Workforce Commission. Prior to this bill, it was 180 days. Now we have a full 300 days for a person who's a survivor of workplace harassment to try to, report maybe internally, try to work that system, and if that fails, go to the Texas Workforce Commission. Just gives them more time to address the situation. So that brings it in line with what the deadline is in a lot of other states. SB 45, also something that I've had a lot of questions about this. The law previously said any business that was less than 15 employees didn't have to comply with the discrimination statute around sexual harassment. So in other words, really, you're only protected under the law if you work at a larger agency or organization above 15, and it does apply to all state agencies. But that really left out a whole lot of people that there's a lot of people that work at small businesses, mom and pop type businesses, all over the state, and they were just left out of those protections. Now, this bill requires these protections to apply to all businesses, no matter the size. So that's a very good thing. SB 282 simply bans the use of public money to be used in a sexual harassment lawsuit that's against a member of the legislature. In the past, they could kind of pay these settlements off with public money, and that's no longer allowed. So that feels like a real good decision that was made to change that. And all of these we supported in one way or another. With although they were not our priority items, we did submit written testimony or oral testimony to support each of these. We're very much in favor of these. And lastly, this is expanding the harassment statute. SB 530, Senator Huffman carried this, and essentially it tries to close a loophole in the harassment statute. So the harassment statute previously prohibited harassment done by direct communication, and that was typically thought of as text messages or private messages to a victim's maybe account, but it didn't prohibit harassment that was just posted on social media platforms, for the public to read, slanderous type of harassment that might occur. And so now any repeated instances of this nature is going to be included in that harassment statute. So we believe that's a very good thing in trying to crack down on kind of the revenge porn stuff that we've seen in this field. So, we could go on, and maybe some of you wish that we would, but in the interest of trying to reserve some of your time for questions, we did want to cut it off and go through the chat and see what kind of questions y'all have asked already. And please do continue to type in your questions. I know I saw somewhere, are we going to be providing this PowerPoint? We absolutely can, and this is going to be recorded or is being recorded, and it will be included on our YouTube channel. So certainly you can go back to it and reference any of the pieces. You can contact us with any questions, but after the fact. But yes, well, right now we'll move to